My name is Caroline May Whitaker, and I was 34 years old the Saturday my mother-in-law sold my grandmother's wedding ring at a garage sale in Bedford County, Virginia, for $40 cash. She set it on a folding card table between a chipped gravy boat and a stack of paperback romances. And she did not know that the man standing across the lawn in a pressed denim shirt was a certified jeweler from Roanoke. I paid for my coffee at the gas station 2 miles down the road, walked back to my Subaru, and I smiled the small, level smile I saved for the end of a long audit. What she did next, in front of my husband, in front of her own pastor, in front of every cousin who had ever whispered behind my back at a church potluck, none of them saw it coming. Stay with me. By the time the magnolia petals fell in October, the woman who had spent 4 years calling me that Whitaker girl was sitting in a probate hearing with her hands folded and her mouth shut, and I had not raised my voice one time. I grew up in a clapboard farmhouse outside Lynchburg, the kind of place where the grandfather clock in the front hall has been ticking longer than anybody currently living. And the porch boards remember the weight of 4 generations of women who learned to keep their accounts in order. My grandmother, May Whitaker, the woman I was named for, raised me on 2 pieces of advice. Write it down, Caroline. And a lady never argues with a liar. She just keeps the receipts. She wore a thin gold band on her left hand, set with a single old European-cut diamond, and she told me once, when I was 9 and helping her shell butter beans on the back step, that the ring had come over from Galway with her great-grandmother in 1898. It had been appraised, insured, and reset exactly twice in 120 years. She left it to me in a notarized codicil to her will, signed in 2017, witnessed by her attorney and her pastor, dated and recorded with the probate court in Campbell County. I keep a copy in a fireproof safe in my home office, behind a framed picture of my son. His name is Henry. He was 6 that summer, freckles across his nose like somebody had flicked cinnamon at him, and he could already name every tractor in his daddy's family's equipment shed by sight. My husband's name is Thomas Calloway. We met at a tax seminar in Richmond when I was 28. He laughed at the right places in a presentation on partnership basis adjustments, which is not an easy thing to laugh at, and I noticed. We married 18 months later in the little stone Episcopal church his great-grandfather had helped build, and his mother, Loretta Calloway, stood in the receiving line in a peach-colored dress and told 3 different women that I was a sweet girl. Even if she does count beans for a living, I am a forensic accountant. I work for a regional firm out of Roanoke, mostly contract work for the Commonwealth's Attorney's Office and a few private estate disputes. I read bank statements the way other people read paperback novels. I find money that has been moved, hidden, renamed, or quietly bled out of a trust account $3 at a time. I have testified in depositions in 4 states. I do not raise my voice. I do not need to. Our daily life was simple. Thomas managed the family equipment business that his daddy had left him. I worked from a home office overlooking a pasture, and Henry rode the bus to a county school where the principal still hand-wrote birthday cards. Sunday afternoons, we drove the 12 miles out to Loretta's farmhouse for supper. Every Sunday, 4 years of Sundays, pot roast, snap beans, sweet tea poured from a glass pitcher beaded with summer sweat, and a low, steady current of disapproval running underneath it all like a creek under a board. It was worth the wait. The first incident I documented was 3 weeks after the wedding. We were at Sunday supper, and I sat down in the chair I'd sat in for 18 months of courtship, Thomas's right side, across from his sister Tessa. Loretta walked into the dining room, set down the gravy boat with both hands, and said, "Oh, sweetheart, that's family seating. Why don't you scoot on around there by the window?" The window seat was on a folding metal chair. I scooted. Thomas didn't notice. I noticed. I wrote it down that night in my phone notes. Sunday, June 11th. Moved from dining chair to folding chair. Elle smiled. I did not know yet that I was starting a record. I only knew that my grandmother had taught me to write things down, and the moment had the small, sharp shape of something that would repeat. The second incident was in August. Henry was 4, and Loretta picked him up from preschool without telling me. The school had her on the emergency list because Thomas had added her without asking. I came to the parking lot at 3:15, and Henry was gone. And for 42 minutes, I sat in my car with my hands flat on the steering wheel, breathing the way I'd been taught to breathe before a deposition. When I finally reached her, she laughed. "Oh, honey, I just wanted to take my grandson for ice cream." "You worry too much," I wrote it down. August 24th, unauthorized pickup. 42 minutes, Elle laughed. The third incident was the Christmas after Henry turned 5. I had spent 2 months hand-embroidering a stocking for him. May Whitaker had taught me the stitch, and I am not a sentimental woman about much, but I am sentimental about thread. I mailed it to Loretta's house in November because she was hosting Christmas Eve, and she'd asked for it early to hang on the mantel with the others. On Christmas Eve, the stocking on the mantel was not mine. It was a store-bought red felt one with Henry's name in glitter glue. My stocking was in a paper bag by the back door, in a pile of things Loretta was donating to the church bazaar. She had not even unwrapped it. She said, "Oh, Caroline, I didn't know what that lumpy package was." I figured it was something old. I wrote it down. December 24th. Stocking recategorized as donation. Unopened. The fourth incident was the voicemail. April of the following year. Loretta called Thomas's cell phone, hit the call instead of hang up, and left 41 seconds of herself and Tessa in the kitchen talking about me. She acts like she's better than us with all her numbers and her city ways. Thomas could have married Bethany Pruitt and had a real Callaway wife. I listened to it twice. I saved it to 3 separate places. I wrote it down. April 9th, voicemail, 41 seconds. Recorded, dated, archived. The fifth incident was the gift returned. My birthday the following October. I turned 33. Thomas had picked out, with Henry's wobbly 6-year-old help, a small silver bracelet engraved with the date Henry was born. Loretta was at the kitchen table when I opened it. She looked at it, smiled the smile I learned to read, and said, "Well now, that's pretty. Tessa, didn't you have one almost just like that? Caroline, sweetheart, you ought to give it to Tessa. It'd suit her coloring better." I did not give it to Tessa. I wore it home. But I wrote it down. October 17th. Asked to surrender birthday gift to sister-in-law. Witness Thomas. Thomas said nothing. That was the line I underlined twice. Thomas said nothing. I closed my phone. I sat on the edge of our bed in the dark for a long time, listening to the grandfather clock in the front hall. The one May Whitaker had left me along with the ring and the codicil and the careful, quiet instruction to keep your accounts in order. And I understood, in the slow way you understand a thing in summer in Virginia, that I had been keeping the accounts for 4 years without knowing why. Now I knew. The public humiliation came at the family reunion. The second Saturday in July on the Callaway farm in Bedford County. 43 relatives in folding chairs under a white tent. A long table of casseroles in foil pans. Henry was 7 by then, chasing his cousins barefoot through the grass, his Sunday shirt already untucked. Loretta had organized the day, as she did every year. She had also organized, without telling me, something she called the family blessing. After the meal, she stood at the head of the long table, tapped a butter knife against a sweet tea glass, and said she had an announcement. The whole tent went quiet. Thomas was at my left elbow. His brother-in-law was at my right. Henry was on my lap, sticky with watermelon. Loretta lifted a small velvet box from her cardigan pocket, and my chest went cold before she opened it, because I knew the box. I had seen it 100 times on my grandmother's dresser. It was May Whitaker's ring. She opened it. She turned to Tessa, who was sitting in the front row in a sundress and a smile she had practiced, and she said, "Tessa Ann, this ring has been in our family for generations. I want you to have it for your engagement. It belongs on a Callaway daughter's hand." The tent applauded. 43 relatives, including my husband. I want you to understand what I did in that moment, because it matters to the rest of the story. I did not stand up. I did not correct her. I did not even change my expression. I lifted Henry off my lap, set him gently on his own folding chair, brushed a watermelon seed off the front of my dress, and I smiled the same level smile I save for the end of a long audit. Tessa walked over. Loretta slid May Whitaker's ring onto Tessa's finger. The diamond caught the July light and threw it across the tablecloth like a small, sharp warning. I clapped twice, politely, the way a lady claps. There was one person in that tent who was not clapping. A boy, Henry. He was 7, and he was looking up at me with his daddy's brown eyes and his great-grandmother's freckles, and he whispered, "Mama, isn't that Granny May's ring?" I leaned down. I kissed the top of his head, and I whispered back, "Yes, baby, it is. We're going to take care of that." That was the witness. A child, my child, The 43 Callaways who knew the ring was not theirs to give. That night, after Henry was asleep, I sat at my kitchen table in our farmhouse in Forest, Virginia, with a glass of unsweetened tea and my phone, and I scrolled 4 years of notes. Sunday, June 11th, August 24th, December 24th, April 9th, October 17th, and now, July 8th. May Whitaker's ring placed on Tessa Callaway's finger by Loretta Callaway at family reunion. 40-plus witnesses. Thomas applauded. I scrolled slowly. I read every entry, and I saw for the first time the pattern I had been documenting without naming. It was not 100 small slights from a difficult mother-in-law. It was a 4-year campaign of substitution. Substitution of seat. Substitution of authority over my child. Substitution of my stitching for a store-bought stocking. Substitution of my voice in a recorded phone call. Substitution of my birthday gift to a sister-in-law. And now, substitution of my grandmother's ring onto another woman's finger. She wasn't trying to make me uncomfortable. She was trying to write me out. I opened a new note. I titled it Callaway, Pattern, and I started, calmly, to organize the chronology. Date, incident, witness, documentation status. I worked until 2 in the morning. I did not cry. I did not call my mother. I made a spreadsheet. Then I made a folder. Then I made a backup of the folder on an encrypted drive in my home office safe, behind the framed picture of my son. That's when I realized this wasn't about a ring. It was about money, because May Whitaker's ring, the old European-cut diamond she'd left me in a notarized codicil, had been appraised in 2019, the year before she died, at $28,400. I drove to my mother's house in Lynchburg the next Tuesday afternoon, while Henry was at day camp and Thomas was at the equipment shed. My mother is 71, lives alone since my father passed, and keeps May Whitaker's old roll-top desk in the corner of her sunroom. I opened the bottom drawer. I knew exactly what I was looking for: the codicil, the appraisal, the insurance rider, and the envelope. The envelope was the part nobody knew about. My grandmother, write it down, Caroline, had not only left me the ring, she had also left me a sealed letter, addressed in her thin, slanted hand to Caroline May, to be opened only if anyone ever questions the ring. I had never opened it. For 3 years it had sat in the bottom drawer of her desk, behind the appraisal folder, waiting. I made a cup of coffee in my mother's kitchen. I sat down at the sunroom table. The grandfather clock from the front hall, the same one, moved here when my mother downsized, ticked slow and steady, and the light came through the magnolia leaves outside the window in soft green pieces. I slit the envelope with a butter knife. Inside were 3 things. First, a handwritten letter, 2 pages, dated June 4, 2019. It said, in part, Caroline May, if you are reading this, someone has tried to take the ring. Likely they did not know it was insured. Likely they did not know it was photographed, registered, and recorded. The serial number of the setting is engraved on the inside of the band. The diamond has a GIA certificate, number enclosed. The ring is not a sentimental object. It is a recorded asset. Treat it as one. Love, Granny May. Second, the GIA diamond grading report. Stamped, certified, with a unique laser-inscribed identification number on the girdle of the stone. Visible under 10 times magnification to any certified jeweler in the Commonwealth of Virginia. Third, and this is the part where I set my coffee down, was a copy of an insurance policy from a regional carrier out of Richmond. The ring was insured for $32,000. The policy had been kept active by my grandmother, paid annually, and at her death the policy had been quietly transferred to my name through her executor. I had been paying the premium for 3 years without thinking about it. It came out of a checking account I used for nothing else. $41 a month. I had not even noticed. The policy had one specific clause my grandmother had insisted on. In the event of theft, unauthorized sale, or conversion by any party other than the named beneficiary, the carrier would file a claim and a report with both local law enforcement and the Virginia Department of Criminal Justice Services, and would coordinate with the GIA for recovery of the laser-inscribed stone. I read the clause 3 times. I closed the folder. I drove home. I did not tell Thomas. Wednesday morning at 9, I sat in the office of an estate attorney in Roanoke I had worked with twice on Commonwealth's attorney cases. Her name was Eliza Bourne. She had the kind of office where the books on the shelves had actually been read. and a brass nameplate on her desk that her father had given her on the day she passed the bar in 1994. I laid out, in chronological order, the codicil, the appraisal, the GIA report, the insurance policy, Granny May's letter, my 4-year spreadsheet, and the audio file of Loretta's voicemail. Eliza did not interrupt. She read for 40 minutes. Then she looked up at me over the top of her reading glasses and said, "Caroline, you have built me a case. What outcome do you want?" I had been thinking about that question for 5 days. I said, "I want the ring back. I want it documented that it was never theirs to give. I want a written acknowledgement from Loretta Calloway on the record that she knew. And I want Tessa held harmless. She was used the same way I was. I do not want criminal charges if I can avoid them. I want this handled the way my grandmother would have handled it, quietly, in writing." With receipts, Eliza nodded once. She wrote down 4 words on a legal pad: civil, recorded, no drama. Then she told me what we were going to do. First, certified mail. Return receipt requested. A letter to Loretta Calloway from Eliza Bourne, attorney at law, citing the codicil, the appraisal, the GIA inscription, and the insurance policy, demanding the immediate return of the ring within 14 days, plus a notarized acknowledgement of ownership, plus reimbursement of all legal and appraisal fees incurred. The letter would also state, and this was Eliza's quiet masterstroke, that under Virginia Code Paragraph 18-2111, conversion of property valued over $1,000 constituted a Class 5 felony, and that the insurance carrier was already aware of the situation and prepared to file accordingly should the matter not be resolved civilly. Second, a cease and desist on any further unauthorized contact between Loretta Calloway and our minor child without my written consent. Removal from the school's emergency contact list. Removal from any document Thomas had unilaterally signed. Third, and this was the part that surprised me, a petition for a protective order. Prepared but not yet filed, sitting in a manila folder on Eliza's desk like a loaded weapon nobody had to fire. Fourth, full stop. That was the phrase Eliza used. "Caroline, after this letter goes out, you do not engage. You do not explain. You do not negotiate at a Sunday supper. Anything that needs to be said is said in writing, through me, on letterhead. Full stop." I said, "Yes, ma'am." I drove home through the Blue Ridge afternoon, the light going honey gold on the pastures, and I did not cry. I called my mother from the car. I told her 3 sentences. She said Granny May knew. "Caroline, your granny knew this day was coming." The certified letter went out Thursday morning at 9:14 a.m. from the Roanoke, Maine post office. Tracking number archived. Photograph of the envelope archived. Receipt scanned and uploaded to the Calloway folder on my encrypted drive. It was worth the wait. Now here is where the garage sale comes in. Loretta Calloway received the certified letter on Saturday morning. I know because the return receipt was signed by her, L. Calloway, 8:47 a.m., and scanned into Eliza's office system by Monday. What Loretta did between 8:47 a.m. and roughly noon that same Saturday is the part that ended the case before it began. She panicked. She did not call Thomas. She did not call Tessa. She did not call her own attorney because she did not have one yet. What she did was take May Whitaker's ring off, Tessa's dresser. Tessa had left it at Loretta's house the previous Sunday for safekeeping, and she added it to the folding card table at the end of her driveway, where she had been running a Saturday garage sale to clean out Daddy's old workshop. She put it in a small white jewelry box with no tag, and she dropped a handwritten index card next to it that said, in blue ballpoint, "Costume, $40. She did not know the ring was laser-inscribed. She did not know it was insured. She did not know about Granny May's letter. She also did not know about the jeweler. His name was Wade Hollings. He owned a small shop on Campbell Avenue in Roanoke called Hollings Fine Jewelry since 1962. He had appraised the ring for my grandmother twice, in 2003 and 2019. He was 61 years old, wore pressed denim shirts on Saturdays, and on that particular Saturday, he was driving back from a granddaughter's softball game in Bedford when he saw a hand-lettered sign at the end of a long gravel driveway. Garage sale, today only. He stopped because his wife had asked him to look for old Pyrex. He saw the ring on the card table from 12 feet away. He told me later that he recognized the setting before he was close enough to read the index card. He picked it up. He turned it slowly under the July light. He saw, without a loop, just from memory, the small Whitaker maker's mark on the inside of the band. He paid Loretta Calloway $40 cash. He drove the ring back to his shop in Roanoke. He locked it in his safe. He called his daughter, who is a paralegal at Eliza Bourne's firm. His daughter, whose name is Grace, called Eliza. Eliza called me. I was at my kitchen table with Henry, helping him with a coloring book. I stepped onto the back porch. I listened. I said, "Eliza, please tell Mr. Hollings I will be at his shop in an hour, and please tell him I will reimburse the $40 in cash with my deepest gratitude." I drove to Roanoke. Wade Hollings handed me the ring in a small velvet box. He also handed me a single sheet of paper, a written, signed, dated, witnessed statement, prepared in the 40 minutes between his daughter's call and my arrival, attesting that on that morning, at approximately 10:15 a.m., he had purchased a diamond ring matching GIA report number such and such, bearing the Whitaker maker's mark, from one Loretta Calloway at a public garage sale in Bedford County, Virginia, for the sum of $40 United States currency, and that the seller had represented the item as costume jewelry. He had also taken 3 photographs, one of the card table, one of the index card, one of Loretta Calloway's hand placing the bills in the cash box. I thanked him. I paid him $40. I added $35 more for his professional time and a box of Belgian chocolates for his wife. I drove home with my grandmother's ring in my pocket and a manila folder on the passenger seat that had just become the most expensive $40 purchase Loretta Calloway would ever make. The Sunday supper was 3 weeks later. I had not been to one since the reunion. Thomas had asked twice, gently, when I was coming back to Mama's table. I had said, soon. I had not said, with an attorney's letter, a GIA report, 3 photographs, and a signed jeweler's statement. The certified letter from Eliza had given Loretta 14 days to respond. Day 14 was that Sunday. She had not responded. That was, in Eliza's quiet words, fine. Silence builds the record. We arrived at Loretta's farmhouse at 1 in the afternoon. Thomas drove. Henry was in the back seat with a library book about tractors. I had a manila folder in my lap. I was wearing a plain cotton dress the color of cream, my hair pinned back the way my grandmother used to pin hers, and the only jewelry on my hand was a thin gold wedding band. May Whitaker's ring was in the home safe in Forest. I did not need it on my hand to make the point. I had photographs. The dining room was full. Loretta, Tessa, and her fiancé, Thomas's brother Caleb and his wife, 2 aunts, Pastor Briggs from the Episcopal Church. Loretta had, I learned later, invited him for moral support, though she had not told him for. 8 adults at the table. Henry on a stool by the sideboard with a plate of biscuits. We ate. I was polite. I passed the butter when asked. I complimented the snap beans. Loretta did not look at me. Tessa did not look at me. Thomas looked at me twice and could not read my face, which was, on purpose, unreadable. When the plates were cleared and the iced tea was refilled, I set my napkin beside my plate. I lifted the manila folder onto the table. I said, in the voice I use in deposition prep, clear, unhurried, precise, "Loretta, before we have dessert, I'd like to read something into the record of this family. It will take about 6 minutes. I'd be grateful if no one interrupts." The room went still. Pastor Briggs set down his glass. I opened the folder. I read, first from the notarized codicil to May Whitaker's will, dated April 2017, leaving the diamond ring known within the family as the Galway ring to my granddaughter. Caroline May Whitaker, in fee simple, with no encumbrance. I read the witness signatures. I read the recording stamp from the Campbell County Probate Court. I read, second, from the 2019 appraisal, $28,400, and the insurance policy, $32,000 coverage, premiums paid by Caroline May Whitaker since June 2021. I read, third, the GIA diamond grading report, laser-inscribed identification number, engraved on the girdle, visible at 10 times magnification. I read fourth from Granny May's letter. Just the one line. The ring is not a sentimental object. It is a recorded asset. Treat it as one. My voice did not shake. Pastor Briggs lowered his eyes. I read, fifth, the signed and witnessed statement of Wade Hollings, jeweler, Hollings Fine Jewelry, Roanoke, Virginia, dated July 27th, attesting to the purchase of the ring from Loretta Calloway at a public garage sale in Bedford County for the sum of $40. Represented as costume jewelry. I slid the 3 photographs across the table. Card table. Index card. Loretta's hand on the cash box. They moved past Tessa, past Caleb, Briggs, and came to rest in front of Loretta. She did not pick them up. I said, and this is the part I had practiced in the car on the way over. The way I practice testimony. I'm not here to argue. I am not here to shame anyone. I'm here to read the record. The ring belongs to me. It has belonged to me since April 2017. It was never yours to give to Tessa. Tessa, sweetheart, I want to say this directly to you. I do not believe you knew. You were used. I hold you harmless, and I would like us, in time, to be friends. The party I am addressing is Loretta. I turned my head. I looked at my mother-in-law. I did not raise my voice. I said, Loretta, the certified letter from my attorney was delivered to you on the morning of July 20th at 8:47 a.m. Within 4 hours, you removed the ring from Tessa's possession and sold it at the end of your driveway for $40. That act is on photograph and on a signed jeweler's statement. Under Virginia Code paragraph 18.2.111, that is a Class 5 felony. The insurance carrier is aware. They have not filed. They will not file if, and only if, you sign the acknowledgement of ownership my attorney prepared. Reimburse legal and appraisal fees in the amount of $4,200 on a written repayment plan, and agree in writing to the boundary terms I am about to read. The grandfather clock in the hall ticked. Loretta's mouth opened, then closed. Tessa was crying quietly into her napkin. Thomas was looking at me with an expression I had not seen on his face in 9 years of marriage. The expression of a man who is realizing, in real time, that his wife is not the person he had allowed his mother to describe her as. Caleb said, Mama, what did you do? Loretta did not answer. I closed the folder. I said, starting today, hear how this works. I read from a single sheet of paper Eliza had drafted. 1. The ring is returned. It is already in my possession. The transaction with Mr. Hollings is documented and lawful. 2. Loretta will sign, before a notary, the acknowledgement of ownership. Eliza Bourne will provide the notary. The signing will occur within 7 days. 3. Loretta will repay $4,200 in legal and appraisal costs at $300 per month. By certified check, mailed to Eliza Bourne's office, return receipt requested, beginning on the 1st of next month. 4. All future contact between Loretta and our minor child, Henry Calloway, will occur with my written advance consent. Loretta is removed, effective immediately, from his school emergency contact list. She is removed from any document that grants her authority over him. Visits are scheduled, supervised by either Thomas or myself, and documented. 5. All future communication from Loretta to me will be in writing. Email or letter. No phone calls. No drop-ins. No Sunday suppers until further notice. If she chooses to communicate verbally to Thomas, that is between them. She will not communicate to me through him. 6. The petition for a protective order is prepared, signed, and sitting in Eliza Bourne's office. It will not be filed if the above terms are met. It will be filed without further notice if they are not. 7. Choose your dignity. I folded the paper. I slid it across the table to Loretta. I stood up. I walked into the kitchen. I poured Henry a fresh glass of milk, and I asked him, gently, if he was ready to go home and feed the chickens. He nodded. He took my hand. Thomas stayed at the table for 9 more minutes. I do not know what was said in those 9 minutes. I have never asked. He came out to the car. He sat in the driver's seat with both hands on the wheel for a long time. Then he said, Caroline, I am so sorry. I should have seen this years ago. I said, I know, Thomas. Drive us home. He did. The notarized acknowledgement was signed the following Thursday at Eliza Bourne's office, with 2 paralegals as witnesses. Loretta wore a gray dress. She did not look at me. She did not need to. The signature was the document. The document was the record. The first repayment check, $300, certified, mailed return receipt, arrived at Eliza's office on the 1st of August, then September, then October. By the following spring, the $4,200 was paid in full. I have the 14 receipts in a manila folder behind the framed picture of my son. The Sunday suppers did not resume that summer, or the fall, or the winter. The first one I attended again was the following Easter, 9 months later, and only after Loretta had written me a 4-paragraph letter, handwritten, mailed, that did not contain the word sorry, but did contain the sentence, "I did not know what I had in front of me." I read it twice. I filed it. I went to Easter dinner. I sat in the dining chair on Thomas's right side. The folding chair by the window had been removed. Tessa and I are friends now, slowly, carefully. She married her fiancé the following October, at a small ceremony at the Stone Episcopal Church, and she asked me to do a reading. I read from 1 Corinthians. I wore a navy dress. On my left hand was a thin gold band. On my right hand was Granny May's Galway ring, resized by Wade Hollings free of charge for the trouble. Pastor Briggs and I never spoke about that Sunday again. He nodded at me once in the church parking lot. The next time I saw him, I nodded back. That was enough. Henry is 9 now. He still remembers the reunion. He has not asked about it in 2 years. The last time he did ask, I told him, "Baby, your great-grandmother taught me to write things down." That's all I did. I wrote things down. He thought about that. Then he said, "Mama, I want to learn how to do that too." So I bought him a small leather notebook. He keeps it in his desk drawer. I have not read it. It is his. The grandfather clock from my grandmother's front hall now sits in my front hall in Forest, Virginia. It still ticks slow and steady. The pasture light comes through the magnolia leaves in soft green pieces, the same way it did that afternoon at my mother's sunroom table when I slit the envelope with a butter knife. Loretta is 76 now. She and I exchange Christmas cards. She writes mine herself. She signs them Loretta. Not Mama, not Love, just Loretta. That too is the document. That too is the record. I have not raised my voice one time. My grandmother told me, when I was 9 on a back step shelling butter beans in the long Virginia light, that a lady never argues with a liar. She just keeps the receipts. I did not understand her for 25 years. I understand her now. The women in my family did not survive 4 generations of men and money and land by raising their voices. They survived by writing it down, by keeping the codicil, by paying the premium, by saving the voicemail, by trusting that the truth, calmly entered into the record, would outlast any Sunday supper in any dining room in any farmhouse in Bedford County. Choose your dignity. Keep your accounts in order. And when the moment comes, and it will come, do not scream. Do not beg. Do not cry in front of them. Open the folder. Read the record. Close the folder. Go home. If this story moved you, subscribe. There are more women like me, and we are no longer staying quiet.